Can you hear me now? Yeah, now it's working very well. Good afternoon, everybody. Thanks for joining this session. This afternoon, as you can see from the title behind me, we are going to focus on private enforcement and litigation funding. My name is Stefano Catellani. I'm an Italian lawyer based in Geneva, where I have been working for a long time after a career working in-house in Italy, in Belgium, and in Switzerland. And nowadays, I'm in private practice, and I'm also teaching international business law at the American University there. As I have said, we will focus on these two aspects, and here I have two eminent speakers on my right side, if I can start from the right, but maybe it's totally, how to say, free in terms there is no order. Let me find the right CV. Charles Desmoulins, who is working for this litigation fund, Deminor, who is sponsoring our event, and he is Chief Investment Officer there, focusing, among other things, on antitrust laws. Before that, he was a lawyer in private practice, working at Allen & Overy. And he is also a member of a European Association of Litigation Funding, which is called ELFA Association. And as I mentioned before, his area of focus today is primarily collective redress. He has a Master of Laws from Louvain and also a degree in corporate finance from the same university. On my left, Francesco Anglani. He is the head of the antitrust department at Bonelli Erede, and obviously he's focusing on all aspects of antitrust legislation, including merger controls and, among other things, private enforcement, which is a growing area of activity on which the firm is investing seriously. Francesco has been with Bonelli for many years, before in Brussels and in London, and eventually in Rome. And he has an LLM from King's College and also a PhD from the same university. Before we start, maybe it would be useful, I don't know how many of you are familiar with the instrument of litigation funding. Some are, some maybe are a bit less. It's not an instrument which has been particularly used and developed in Italy, but it's certainly growing. Litigation funding is nothing else than a form of financial support where you have a funder who is financing a litigation in exchange for a share of a return. So in very simple words, it's like a contingent fee, for those who are familiar with this contingent fee in the US practice, but it's done by non-lawyers. It's done by organizations who are financial companies, financial organizations, and of course they don't have the same restrictions which apply to lawyers in private practice. Litigation funding is active in various areas. I guess probably the three main areas, especially in the Italian market, are insolvency procedures, antitrust cases, and obviously arbitration, especially important commercial arbitration, also investor-state arbitrations, which are obviously more expensive, therefore they require the intervention of such an instrument more frequently. Today, obviously, we're going to focus on their role in the area of private enforcement. And concerning private enforcement, again, I don't want to say too many things, because otherwise the two main speakers here will be deprived of their subject of discussion. But at the same time, it might be useful to mention at least what are the issues which can be identified already at this stage, especially from the point of view of somebody like me, who used to be an in-house lawyer for many years and have contemplated the possibility of using this instrument in the past several times, and it wasn't always easy. It wasn't always easy because despite the fact that private enforcement is developing, and as Francesco will tell us, is developing also in a substantial manner in the Italian market, also with the support of the European institutions, because the European Commission has been behind it in many occasions and is clearly pushing for private enforcement as a complement to public enforcement. But still, at least from a point of view of users, there are some question marks which we are trying to address in our discussion today, because our discussion will be structured in three parts. First, Francesco will tell us more about the development of his instrument in Europe and more specifically in the Italian market. Then Charles will talk more about the use of the litigation funding in general in Europe and also in the Italian market. And then in the end, we'll try to address more specifically these issues, which I can already list now. What are the potential obstacles? And the potential obstacles from the point of view of user, of the claimants, of the potential litigants, are mainly, I would say, three. Well, first of all, you are confronted with a situation where you might have to take action against some of the people which you need in your business activities. They can be competitors, but more often you're talking about suppliers, or in some cases even customers, people who you need to continue to do business with. So it's not always easy to take that decision. Second, there are issues concerning, the complexity, the duration, and obviously the cost of a case, which are important elements which need to be considered, and sometimes they can discourage a decision in that area. And then, last but not least, is the amount of the recovery. How much am I going to get out of this? Is it attractive enough to justify the need to overcome these obstacles in terms of effort, cost, duration, and complexity? And so we try to address all these aspects in the third part of our discussion. But now, without further ado, I'll give the word to Francesco, who will talk to us about the legal environment surrounding private enforcement in Europe and in Italy. Thank you, Francesco.
Thank you very much, Stefano. Thank you very much also to Charles and Domino for the invitation. Thanks a lot, of course, to LEAR, and congratulations to Paolo Buccirossi and LEAR to organize this amazing event. When we started discussing with Charles and the others about this panel and the discussion that we could have, at the end of the day, we started asking us questions. Is the Italian market ready for the litigation funding? Maybe we will discuss this point later on, but we started in our assessment and in our evaluation from a couple of facts. First of all, we all know that the proper antitrust enforcement requires both an effective enforcement carried out by the competition authorities and also an effective private enforcement systems. This is something that we have been heard for many years, and we are certainly convinced right now that this is true. But we also know that historically we have assisted a scenario where in the United States the antitrust enforcement is predominantly private. Generally, we say that 1 out of 20 cases are public. Of course, we know that there are many reasons for these: treble damages, discovery, contingency fee, and so on. But in Europe, we assisted an opposite situation where the public reports provide that until 2005, only 100 actions for damages were brought in Europe. So the situation is completely opposite from the one that we see in the United States. Now the question is, the scenario is changing in the next future. In my view, yes, for some reason. First of all, the European Union adopted a directive All known that the private antitrust, the private enforcement directive provide many simplification for the plaintiff. First of all, they provide the bind effect of the decision of the competition authority. Secondly, there is a presumption of damages in cartel cases, and also there is an exclusive jurisdiction provided by the damage decree of the specialized court in Italy for Rome, Milan, and Naples. And this is for sure increase the quality and the timing of the decision. Secondly, there are a number of decisions of the Italian civil courts and also some rulings from the European Court of Justice that certainly helps the assessment of chances of success in this kind of claims. Thirdly, and a bit controversial, is the leniency. My impression is that the leniency starts to be more common in Europe and also in Italy. And of course, this increase the possibility of succeed in the civil cases if you start the action against the leniency applicant. And this trend seems to be confirmed, in my view, also by the fact that in Italy has been recently adopted the settlements procedures before the Italian Competition Authority. All of these points, in my view, could drive to a cultural change in the next future in the private action. But this is also confirmed by numbers. If we have a look at the, I would say, 10 years, our past 10 years, we can certainly understand that the antitrust damages cases in Italy have grown a lot. And we passed from the mentioned 10 cases in 20, 30 years ago. Now we have more or less 100 cases each per year. And not only follow-on, but also standalone cases. And if we also have a look at the kind of actions, they are completely different from the past. We don't see only the big telecommunication companies doing this kind of action, but also we register great interest in this type of litigation by companies of different size, sector, characteristics, and this is confirmed if you have a look at the cases. We now are pending in Italy a plethora of follow-on action brought on the so-called truck cases. There is a cartel on international TV rights in Italy that has been ascertained by the Italian Competition Authority in 2019, and where the Liga Serie A and 17, if I remember well, soccer clubs started an action for around 3 billion euros. There are price-fixing cartel cases for the producer of cardboard that is now pending in Italy, and also the damage action brought against the main Italian producer of cement. All the above, in my view, makes clear the private enforcement, the private antitrust enforcement is a perfect ground for litigation founding in Italy. First of all, there is, based on the procedural rules that has been enforced in Italy right now, you have a high chance of success, especially in cases that are characterized by leniency application, where our impression is that at the end of the day, you will focus the discussion mostly on the quantification of damage rather than on the end of the violation and the claim. And nowadays also small and medium enterprise are very interested in this kind of action. In my view, therefore, this will not only increase the overall number of action, but will also increase the interest for a potential litigation in founder in Italy, and also for plaintiff to look for a founder in order to be financed. I mean, this is my initial view on the development of the private enforcement in Italy. Maybe we can start from here and go on the discussion.
Yeah, for sure. Now it will work. Thank you very much. I think this is very interesting. I mean, I have plenty of questions which I will reserve for later, but I guess at least a couple of immediate comments can be made. On one side, we can see a clear trend upwards, in the sense that before practically we didn't have any antitrust action, only 10 per year, or 10 altogether, until a few years ago. And now all of a sudden we can see a drastic surge. So that indicates that there is a totally different level of interest from various parties. And on the other side, again, the increase in the number of leniency applications. And as you know, when you ask for leniency, practically means that you're confessing your sins, and obviously then your liability cannot be questioned anymore. So it becomes just a question of how much. Okay, and now I guess it's before we start our discussion, it's probably very important also to hear the view from the point of view of a litigation funder, and maybe you can tell us also something more about your experience outside of Italy, correct?
Certainly. Thank you. Thank you, Stefano. Thank you, Francesco, as well, for introducing the context from a legal point of view. Good afternoon to all of you. It's true, as you said, Stefano, litigation funding is not only about antitrust. But if you look at different countries in Europe, the two almost go hand in hand. It's not common to have a very large antitrust litigation pending somewhere in Europe if you don't have a funder involved. And why is that? Why do litigation funders want to invest in this type of claim? Because there are lots of different claims, and of course we, including at Demino, we invest in multiple types of litigation, from arbitration, M&A litigation, intellectual property. But why do we think that there is a potential in antitrust? And we're far from being the only ones. First, it's because of, I would say, simply because of the cost. Funding is required and helpful whenever the budget is rather high. And it's no surprise in antitrust litigation, not only public enforcement, but mostly private enforcement, the costs can be extremely high. It's not only the lawyer's fees, because funders, obviously litigation funding, it says it all in the name. Funders cover the costs of lawyers, but funders also cover the costs of economic experts. Funders cover the costs for advisory. Sometimes also it can involve some PR exercise. The administrative cost of managing a large group of plaintiffs in collective and group actions. And you also have the risk, because that's also the role of litigation funders. They will either protect the corporation against the risk of having to pay adverse party costs if they lose the claim, if the claim is dismissed, or they will pay the premium of the insurer. It's called after the event, ATE. So if you ever hear the name ATE, it means after the event. It's a special type of insurance, which can also be very costly. So it's about the cost. But on the other hand, it's also about the volume, because funders know how much they may have to spend, more or less, but then they will say, what's the potential return? And something specific about antitrust, impact, so the number of victims can be very large. It's typically the case for cartels. Abuse of dominant position can also lead to lots of victims. Illegal state aids, which is something that has not been developed yet to a very large extent, but could be the next step in private enforcement. Usually it's more limited number of victims. But so you are talking about huge numbers in terms of losses suffered as a result of a cartel. So huge costs, but also potential huge damages for the victims. Funders like also the idea of having, if it's a follow-on claim, having, I don't say absolute certainty, but you no longer have to start proving something wrong happened. If it's a follow-on claim, you can rely on the decision of the competition authority, which is binding. That was already the case for the European Commission. Now it's also the case for the national competition authorities. And it's not the same legal value if we are talking about a foreign competition authority, but already still it's a, I think, prima facie value in terms of binding effect. So that helps. It lowers a bit the risk for the funder, but still you are confronted with the uncertainty of the timing, because this kind of litigation takes a lot of time, and as everybody knows, time is money. And two, it's sometimes also, well, almost not sometimes, most of the time, it's the uncertainty on the impact of the infringement on prices or on the profit margins of the victims of the infringement. So this means, this is to explain why funders are interested in this. There are lots of potentials. From the point of view of the victims, it's also interesting to rely on funding, because most of the time the victims of infringement, like a cartel, will be SMEs. And they don't necessarily have the resources, financial resources, to invest in their individual litigation. So that's why they will, if they are being offered the possibility to join a collective action or being funded by a third party, they will say that makes it easier for me to defend my rights. But you should not believe that funding is, and private enforcement is something only for the SMEs. Very large corporations can perfectly be interested, and I think they are interested in pursuing claims for damages, and they may also say, why shouldn't I rely on the litigation funder even though I have the resources? Then you're talking about smart cash management. The example we often take is the in-house counsel saying, I used to be considered by my management and my colleagues as a endless drain on cash flows because I have to spend money, but they don't see anything coming back. Now with litigation funding and private antitrust litigation, but also any type of antitrust, if I use litigation funding, I will be the one saying to my colleagues and my management, I didn't cost you anything, but I'm bringing you money back without any cash outflow from the corporation. Now, how do we do? We have to understand the case. People shouldn't think that litigation funders are ready to jump on any potential litigation they see. It requires a lot of work. We call that research and development. Well, I call that research and development. It's R&D, so you need to invest. So the funding already starts at the time of the analysis of potential case. You want to learn more about the economic impact, so you may have to spend some money on economic experts already at the initial start. You may want to seek a legal opinion from a lawyer also to be sure is it worth investing in this litigation. You have additional complexity in Europe with what people call the forum shopping, because quite often people will say you can litigate anywhere, and the ECJ has developed a body of case law that makes it easier for plaintiffs to select the place where they want to litigate. Not absolute flexibility, let's be clear, but it's easier now than before. The main advantage is being able to bring all the members of a cartel before one court, provided that court is the court of the member state of one of the members of the cartel. That makes it easier for funders. Now, what we see outside of, let's say, in the broader European context, we often hear people say there are three highly mature markets for private antitrust litigation: United Kingdom, the Netherlands, and Germany. This is to a large extent true. You just have to look at the statistics, the number of cases brought to the UK before the CAT. I think, well, I've subscribed to this news firm that sends every day news reports, media reports on anything happening in the field of competition law. And I think every week I see, oh, a new claim brought before the CAT. Like MasterCard, Visa, it's almost every 2 or 3 weeks, boom, we have a news item. Someone is bringing a new claim against Visa or MasterCard in the UK. Or it's about the truck cartel, boom, another one. So UK are very popular, in spite of Brexit, Germany as well, and the Netherlands. I think the advantage they have is that they have developed a body of case law that provides a bit more visibility on the organization of litigation, not necessarily on the merits of the case, but on how to organize private antitrust litigation, whether it's assignment of claim, collective actions, jurisdiction, applicable law, etc. But we now see, since a few years, much more interest from parties in Italy and also from Spain. These are the two countries, the two large markets in Europe where you see a huge growth in private antitrust litigation. In Spain, currently, it's a lot about the truck cartel case where it looks like they are all bringing individual claims. I think I saw a report saying that there were over 2,000 court decisions, first instance, already now in Spain, and close to 500 decisions by courts of appeal in Spain. But in Italy, I think the truck cartel case, Naples, the court in Naples has already issued a decision. So we really see the Italian market maturing in that field. So, and we personally believe that, yes, you could say European cartels, maybe there's a head start for UK, Germany. Well, UK will have to see with Brexit, although we will not see the immediate impact of Brexit. It will take some time. Netherlands and Germany, but I think Italy is going to catch up rapidly. It will mostly depend on what the courts, the specialized courts will do, and the work done by lawyers in Italy to also establish a body of case law. But ultimately, and then I turn to Stefano, it primarily depends on the corporations and the businesses, because that's a big difference with the US and to some extent the UK, where it's opt-out, and then you have law firms and funders able to bring some, well, litigation without necessarily finding all the victims. But in Italy, I don't think it exists, meaning that if you want to litigate in Italy, corporations, businesses have to take the decision of bringing a claim. And so the question is, what would hold them back? If we hear Francesco saying there's a great potential, we say we have the money to invest, what do you think could be an obstacle?
That's a very interesting question. I guess now we can play a little bit of theater, and we do a little bit of commedia dell'arte since we are in Italy. So let's assume that we are in my office. I'm a general counsel of a company X. These two gentlemen have come to see me, and they're trying to convince me to start with this legal action, but I still have some doubts. And therefore, I can ask questions, if you don't mind. May I? So we started to talk about cost, and cost, it's clear, because you know, what I understand from what you said up until now is that you pick up a bill, so that's perfect for me. Sounds like music for my ears. But what about recovery? Because I know, as you also mentioned, that in the US you can have treble damages, which is 3 times the damages. In Europe, there is no overcompensation, and in addition, there is the so-called pass-on defense. So is it really worthwhile the effort?
Up to you.
Well, That's where we share the pre-litigation due diligence. We have a common interest in identifying whether or not it's worth doing it. I think it always starts with a rough estimate of what could be the harm done to your business. And I would assume that Francesco will have the same attitude if you would go directly to him without involving a funder and say, Francesco, is it worth for me to do it? Francesco, being also business-minded, will probably tell him, well, let's see if it's really worth it from a financial point of view, right?
Sure. Yeah, in my view, of course, the point is certainly costs. But you certainly start with an indication on how the case strong is. Of course, if the case is strong and if you, I mean, my impression is that at the end of the day, we will certainly discuss about an happy problem. I mean, the point is, I will get money, yes or no. If you will get money, and very often it happened to me that the cases that we have seen in Italy in the last years are strong cases. The only very extremely difficult point is to have an idea on the real damage that you can suffer. But at the end of the day, this point, first of all, there are very good economists, and LEAR is one of them, so they will certainly help you in better understand what's going on. And in any case, if you are going to speak a huge amount of money, and many often it happens, the discussion on yes, but I really would like to know right now how much I will get at the end of the case, to me, it's not the real point, because there would be a lot of money anyway, especially if someone paid the case for you. So the only point that you should ask, in my view, is I'm sure that I will get an amount extremely higher than the one it cost to Demino or another founder. If the answer is yes, there is no point, no discussion from my view.
Okay, very good. Thank you to both of you. Okay, you have convinced me that at the end of the day, the risk is, in any case, somewhat limited because you pay all the cost. I assume you would pay also the cost of the economists, because I guess that can be also a substantial cost, economists, accountants, whatever. And you will also help me to find them, okay? Or maybe you will bring them in, because I don't know too many of them.
Yes, but that's where there is a difference between collective actions and individual claims. Collective actions, you tend to create economies of scale, and you will say, let's try to hire one expert that can work for everybody. But in an individual claim, usually the funder will say, it's the client picks the lawyer, picks the expert.
I have my lawyer already.
Good. Good choice. Good choice. And we'll say, okay, if we are also happy with the choice of the lawyer and the economic expert, we'll say we'll fund it. But it's true that in collective actions, you need to play with the economies of scale. Also knowing, and that's a big, because I know there are lots of experts here in the room, they will say it's all about data. The good thing, and that is also sometimes an argument to say, let's do it as a collective action. Access to data is amazing, because then you have a huge amount of data that you can rely on to develop your economic model. And that makes it easier for the defendant to dispute the analysis. Because if you're only one company, you say, yeah, okay, but your economic data only reflects your situation. If you come with a large pool of data, then the analysis is more robust. Hence, the interest of having one common expert working for the entire group. But costs will be covered by the funder.
Okay, that's great. That sounds like music. You mentioned the word which I like very much. You say collective. You know why I like it? Because at the end of the day here, we're talking about doing an action against people I know very well, or we know very well as an organization, and with whom we're doing business on a regular basis. So you know what? We don't want to be too visible. We don't really want to expose our company too much because we don't, I mean, we need these people. So we cannot break the relationship. We cannot come to a point where there is too much tension among us. So how can I achieve that objective of, let's say, reducing visibility?
Well, there are several techniques. One is obviously the collective part where you dilute your exposure. You're not the only one litigating because we see, and it's probably more true of larger firms, and I think Francesco being advising very large corporations, I guess that would be one of the concerns of a client about visibility. Knowing that, and again, I think that's a bit of a misconception about collective antitrust litigation. Yes, it is true, there's a lot of publicity around it. Truck cartel, everybody knows about it. But collective actions do not have to be that visible, necessarily. You can be very discreet. We've done cases in the past for a very large number of plaintiffs, very high-profile clients, and we've always said, we're not going to say anything about your identity. We don't go to the press saying, oh, look, I have this client, I have that client. Because these people will use a funder if they believe that the trust relationship they have with Francesco is as strong as the relationship they can have with us. It's all about trust. Do I work with professionals? And for us, it's more the outcome, the result. We are investors than the visibility and publicity we can create. So one thing is collective, not necessarily with lots of publicity. Two, yes, you can work with the technique of the assignment of claim, which is used a lot in Germany and in the Netherlands. In Germany, it was kind of disputed, but since I think June this year, and a few more decisions previously from the highest court in Germany, they have said it's fine. So there you see case law, visibility, more certainty for the funders. So you can rely on this model of assignment of claim where you actually transfer the claim to an SPV. And therefore, you're not in the front line. So that's a way of avoiding the direct contact with your supplier or your client.
And if I may ask, and what about Italy, since we are in Italy? You're talking about Germany and Holland, if I understood correctly. So can you tell us something about Italy as well?
It is, from what we know, it is possible in Italy. From a civil law point of view, you can do it. It is, I think, similar to what they did in Germany, because if you take France, you may have some risks if you do it while the litigation is already pending. I think you call this in Italian, diritto di ritratto?
Which I don't, yeah.
Di regresso.
Di regresso.
Di regresso.
So that's where you have to be careful. But otherwise, from what we know, under Italian civil law, you can do it.
Because that could be also very interesting for me. You know, I get rid of a claim once forever. The question would be how much you pay for me if we go in that direction, because I want to maximize my immediate return. And so if you tell me I only give you 5% at the beginning, might be less interested.
Mm-hmm. But there are two ways of doing this. One, the way it has been done so far in most countries was it's more a way of bringing people together, of consolidating different claims. So rather than having 2,000 plaintiffs, you have one plaintiff, but acting as an assignee, so on its own behalf. But the assignee has not really paid the economic value of the claim. So the agreement is I pay you a small amount now, but then I will still pay you a percentage of what I will recover, me as the owner of the claim. What you are talking about is a different model. That's where it's more, I would say, bring in your CFO, because that becomes a financial solution where you say, I not only want to get to avoid any problem with my suppliers and clients, I would like to have money now. And for me, cash today is better than much more cash in the future with uncertainty. But that's a
And if I remember
financing.
correctly, that's what you call monetization, correct?
That's monetization.
Which
But in this case, you
there's
buy.
assignment.
But in this case, you buy at the end of the day the credit.
Yes.
But you still have an assignment in case of monetization, or
It's
not
an
necessarily?
assignment, but it's an assignment in which the victim of the infringement may no longer have any economic interest anymore. They may be, and that's usually the advice people give, to say, well, you need to incentivize them, because if you pay them full amount as from day one, they will be all gone, and when you need them because you need some documents, you have a risk that they will say, you know, I no longer care about you, I got my money, I'm happy, now you deal with it. But in that case, actually it's a purchase of a claim.
Mm-hmm. Because in my impression, I mean, in my experience, one of the most problematic point in the discussion in doing or not a case, at the end of the day, is the commercial retaliation. I mean, many of them fear that starting a case with their client at the end is not good, even if the case is solid, or even if the amount is huge. This is always a discussion that you need to cover in a proper way. And probably the only way you have to overcome completely this problem is the assignment, because I imagine that if you buy the credit, it will be them in order doing the case, but if you do all the other option, it will be always the client starting a case, even if it is financed by you. In your experience, do you see other option or other approach in the other countries where you have been financed this kind of action that could be useful in order to solve this problem?
Well, we are involved in the truck case in the Netherlands, and there we are relying on a different mechanism, because we discussed and transport companies. I mean, we have to be careful with the clients, because if you become the purchaser of the claim, then you want the client to be fully informed, because there you may have a conflict of interest at the time of the purchase. Yeah. So that's where we're always happy when the clients have good lawyers, because then they take an informed decision. Yes, it's good, I will sell the claim at this price. What we did in the Netherlands is different. It's a mechanism where we have a power of attorney. So the clients are mandating an SPV, so they are still the owners of the claim, but they tell the SPV, you will litigate on my behalf, for my own account, but you are in front. And I know in some countries it's possible to be represented, so not by, I don't say by a lawyer, but you are represented by a third party as your agent in litigation. And that already creates a buffer with the other party.
Yeah, I mean, that's all very interesting. Thank you very much. I guess, you know, this idea of an assignment is also quite attractive, because in that way you dissociate completely yourself from the claim, although I assume that some of our people will maybe have to appear in court as witnesses or something like that. But at least you can say it's not my claim anymore, and therefore you are not immediately attacked by the other side with some kind of revenge, or in a case I've seen, for instance, you have, you know, a limited number of suppliers. You know very well that as soon as the others know that you are in litigation with one of them, you can immediately understand what they do. They jack up the price because they know that you have one supplier less, or potentially one supplier less. So it's very sensitive. It's a very sensitive issue. But let's assume that we don't sell the claim, we keep it. do you see a possibility to, especially because we have now a funder behind our shoulders, and so we know we had to attack this large company who is much bigger and much stronger than we are. I would assume that in a normal situation, we'll probably drag their feet and they will try to starve us, you know, they will try to drag the case as much as they can, so that at some point in time we'll probably give up. Do you see a possibility that because of your presence, we can increase the chances of having a settlement sooner than later, and also the chances of getting more money in a settlement where we don't settle just for a grain of wheat, but we settle for a substantial amount?
It can help, but I think it's a combination of it's not only the fact that there is a funder. Yes, the funder will send the message to the other party. We have the resources. You can play delaying tactics for years. It doesn't matter for us. It will not impact our situation. We also believe, but that's more the investor and not the lawyer talking, when you have a good case, you have two options. Either you say, oh, I have a good case, it's going to be an easy one, I don't have to spend a lot of money as a funder, and that will be a huge return, it's nice. Or you say, I want to maximize the chances of success. Because it's time, but it's also making pressure sending a message. And I think that's also a choice you have to make as a funder. We also like to pick and to invest in claims that are brought with good law firms. And that's why I give an example. We discussed, there is a case now in Italy about the corrugated cardboard. Francesco and his team are working on the case, and we said we are willing to fund this case. But for us, it's the fact that there is a firm like Bonilla Rede working on the case. We also know that it sends a message to the other party. Yes, we can say with us there will be cash until the end of litigation. So yes, it may take time, but we also want to be sure that in the meantime, the other party knows, oops, okay, so now we have in front of us experts, a strong team, also good economic experts. It means they are really investing and they're believing in the case. So going for the cheap solution as a funder, we think, I mean, you don't have to throw money at the face of everybody, but don't be too greedy and don't, let's say, get the sense that you don't need to spend a lot of money because there's a follow-on claim and you're going to win on everything. No, you go with really the strong team. So it's not only about the money, it's about who are the main actors in the litigation. And the funder is one of them, but it's really a teamwork with the client, with the economic expert, that's going to make the difference. But it's sure, and that sends a strong signal to the other party. It's like, oh my, yes.
So you have to show all the guns, civis, pacem, parabellum, and you can say that you are strong enough to make them afraid and to convince that they're better coming to an agreement rather than go to war.
Yes, and I think that's a sign of maturity. And I think, I mean, having firms like Bonilla Rede willing to involve funders is also a sign of the market in Italy getting more mature, because this is something we also see in other countries. Funding is also used by tier one law firms in large markets, because their own clients also say it's something useful for me. So I think this is showing the maturity of the market. It's the attitude of the legal community in the country.
Do you have any additional? Okay, well, thank you very much. Gentlemen, we have another meeting at 4, so we better go. It was very interesting for me, a very good use of our time. I think you practically convinced me. Let me talk to our managing director and then I'll come back to you, but we are halfway through. Thank you very much.